Hi, good afternoon, everyone. I think most people who are joining will have signed in by now. So, welcome to our One Pump Court Family Law webinar series. Zubair, Andrea, and I are taking you through the concept of parental alienation. Next week, our colleagues Rachel and Roshni will look at local authority interventions in private law proceedings. And later in the month, Imogen and Jamie Preston look at practical guides to assist clients in care proceedings. Now, all three of us practice in the family department. We all have a private law practice as well as finance practice, and Andrea and I also have a public law practice. But for today's purposes, we're focusing on parental alienation, which predominantly, in our experience, arise in private children applications. And so, to kick us off, Zubair will be looking at how the law can help us understand this concept. Andrea will take us through practical steps for managing and running a case, and I'll delve into the area of whether expert evidence can ever help us and how to go about identifying who might be the right expert. So to get started then, Zubair, what's the legal position with respect to the concept of parental alienation?
Thank you very much, James. So parental alienation, there's no widely accepted or adopted definition for it. In the past, CAFCAS have given us a definition. They define it as when a child's resistance or hostility towards one parent is not justified and is a result of psychological manipulation by the other parent. And the courts, so the High Court and the Court of Appeal, have in the past used that definition. Now, in respect of because you'll see from the definition I highlighted, the focus is on the child. So the child's resistance and the child's hostility towards one parent. Now, as a result of that, what we had in the past was a focus on the child, and we also had experts, so parental alienation experts, appointed by the court for the purpose of assessing whether or not parental alienation has taken place or not. But that's no longer the current position. That's no longer the law and the approach that should be followed. So I've highlighted the case of RH there, which is a case in which the previous approach was applied, in which case a parental alienation expert was used and the court gave high regard to the opinion of that expert. But now we have the approach of RE-C. And RE-C is a case from last year. And the key takeaway from that case is that parental alienation is not a diagnosable condition. So we can't have an expert say that this child has been alienated or this child has suffered with parental alienation. And because of this changing approach, CAFCAS have also changed the way in which they approach parental alienation. CAFCAS now look at alienating behaviors. And I've got a link there which links to CAFCAS's definition of alienating behaviors, and that comes from the case of RE-C, which I'll highlight again. And in that case, the court was mainly concerned with the instruction of an expert and whether or not it was appropriate for that expert to look at and diagnose the issue of parental alienation. The whole case is a very useful read, but the key paragraph in that case is paragraph 103. And in that paragraph, what the court did is that it said that the focus should be on alienating behaviors. The focus should be on alienating behaviors as opposed to trying to determine whether or not parental alienation has taken place. And that is why CAFCAS have now revised the way in which they look at things and they focus on alienating behaviors rather than parental alienation itself. Now, so what does that mean in practice? What does that mean in terms of how the courts look at things? Well, the courts will still be focusing on the welfare of the child when it comes to this. The court will be focusing on the long to medium term welfare of the child to decide whether or not, if parental alienation has taken place, what should be the best outcome for that child. I've highlighted there what the court will look at to determine whether or not alienating behaviors have been demonstrated or not. And some of those factors are first, that the child is resisting to engage in a relationship with one parent. Secondly, the child is resistant or reluctant to spend time with the non-resident parent, and it's not a consequence of the actions of that non-resident parent. And finally, the resident parent has engaged in behaviors which have directly or indirectly impacted the child, leading the child's refusal or resistance to engage in the relationship with that parent. So that's what the court will be looking at when applying EWHC in practice. So, Andrea, when we look at EWHC, the current position of the law, what would you say are the practical steps that must be looked at when we look at allegations of parental alienation, and parties who are making the allegations as well as parties who are responding to the allegations?
Thank you, Zubair. So I'm going to be touching on what useful tools we would advise using as practitioners dealing with the issue of parental alienation. As Zubair touched on, that CAFCAS has its own alienating behaviour tool, which they apply in their welfare assessment, which we think is quite useful when considering different factors that you might want to look at. And this concept of alienating behaviour, which is lots of small behaviours, but taken together, can be alienating for the child. So I will take you, so this is the diagram including in the tool, and you can see that on the left, there is an appropriate or justified reaction as to why a child might be rejecting the other parent. So that includes domestic abuse or other forms of harmful parenting. And then we kind of go down the line into the more harmful behaviours. So we've got affinity and alignment, which is, no one's fault really, just a preference for one of the parents over the other. We've got attachment, which is there in the middle, a bit neutral. And then we've got alienation, more towards the harmful side. And that alienation can be intermittent or persistent. And then there's harmful conflict, which is also something that's harmful to the child. So looking at behaviours that can be exhibited by a child that you can touch on when you are trying to make allegations on behalf of your client that there has been alienation, you can refer to the child's opinion being unjustifiably one-sided. So that's for better or for worse. It can be all good about the parent with whom they are living, or all bad against the other parent. They might be idealising one of the parents over the other and devaluing the other parent with whom they don't live. They might be given irrational reasons for not wanting to see the parent, for not wanting to have contact with the parent. And that's usually a sign or a hint that there may be parental alienation. There may be situations where there are allegations of harm made by the child, which are then found to be not true or unsubstantiated and just haven't occurred. And that's another sign that there could have been alienating behaviour happening in the background, which has led the child to make false allegations. It's also important when there is already contact between the other parent and the child to check whether there are disproportionate reactions to that parent's behaviour. For example, if a child attends contact in a contact centre and the other parent brings them a gift, if that child has a visceral reaction or refuses to accept the toys or the snacks or whatever it is, without any real reason for that, that might be a sign that there is alienation there. Another thing that CAFCAS talks about is talking negatively about the other parent without being prompted. So that's when CAFCAS or the professionals try to have direct work with the child, and immediately the child starts, reeling off the reasons why they don't want to see that parent or don't like that parent. There's also this element of revising history. So what that means is, for example, if they are saying, well, my dad hit my mum, but the allegations were at a time when the child could not possibly remember that, or, for example, if they weren't born. So that's another sign that there's been alienating behaviours. So there are more factors that we can touch on, but the idea is that if we are making those allegations against the other parent, whether that's in written submissions, in our position statements, we need to be able to evidence that it's disproportionate. I hope you can all still hear me. The camera's gone off. I'm just going to check the chat. If someone could let me know if you can hear us.
Participant 61.
Oh, we're back. I hope you can all still hear us. So I'll just carry on. But the idea is that if you are making the allegations of, oh, there's a raised hand. Okay, you can hear us, but the chat is disabled. Thank you. I don't know if there is a way to not disable the chat, but thank you for just confirming that you can hear us. And I guess when we come to questions, you can just use the question tab to ask us questions there. So thank you. So when you are making the allegations, it's important to show that there is an irrational or unjustifiable element to the child's behaviours. We're now going to turn to behaviours exhibited by the alienating parent. So that is the parent with whom the child is spending the most time with or living with. So what CAFCAS lists as some of the factors that might indicate alienating behaviour is that they actively denigrate the other parent to the child or exaggerate their flaws, whether that's directly or indirectly. They might also ask other people to do this. Abdicating PR. So that means that in every other aspect of that child's life, they tell them what to do and help them to make the best decision. When it comes to their relationship with the other parent, they all of a sudden take the hands-off approach and say, I won't make them something they don't want to do. Similarly, if they use phrases like, I don't want to force my child, I don't want to drag my child, or such loaded language when talking about contact or seeing the other parent. If they are coaching or instructing the child on what to say, usually you can tell by the language used by the child if they use language that is a mirror of what their parent says, or just really advanced language, or that's phrases that adults would be heard to be saying. Other examples of alienating behaviour is, for example, applying to court to reduce contact for no good reason, refusing any positive contacts about the other parent, putting emotional pressure on that child to reject the other parent, whether that's overtly or covertly making threats that if they don't reject that other child, they are going to withdraw their love. And that's a scenario that you often see. And again, it's this unjustifiably negative portrayal, disproportionate reactions. So, rejecting gifts from the other parent on behalf of the child, a distorting history, and not correcting the child's defiant behaviour towards the other parent. So if normally they would not accept their child acting a certain way, but when it comes to the other parent, again, now it's all hands off. I can't force them. I will let them do what they want to do. And the key thing, again, when trying to demonstrate that a parent is showing alienating behaviours is that the evidence will be key. Any sort of evidence that you can rely on that points to any of these things will very much help your case if you are making the allegations or acting for someone making the allegations. And as set out in the case law and in the CAFCAS alienating behaviours tool, the key thing is whether there is a justifiable or an appropriate reason for the child's rejection. So the factors that I've just gone through, they're not an exhaustive list. You can probably, in various different cases, find other behaviours that point to alienation. But the idea is that there needs to be a pattern of behaviour, and that behaviour, the reaction needs to be unjustifiable. So in a case where there was domestic abuse against the alienated parent, against the alienating parent, and the child was a witness to that, they might say, I saw my dad hit my mum, that's why I don't want to see him. That is a justifiable reason. Similarly, if they have personal experiences or harmful parenting or memories of that parenting, that's also a justifiable reason. If they say, my dad used to hit me, or that parent used to have substance abuse issues, or they neglected me, those are justifiable reasons. Anything other than that, where you can't really pinpoint what it is about the other parent that they are so averse to, or why they're having these very big reactions and are so committed to not having any relationship, that's when you can start to look at what the other behaviours are in the background, any of the other signs that we've gone through that there has been alienation. So if you are defending allegations of parental alienation, what you want to make sure you're doing is pointing to those justifiable reasons and going, this isn't out of the blue, this isn't any of my clients doing, the child feels like this because of that, and you need to have evidence of that to back up your case. So I think we're now going to turn to the role of experts, and James is going to tell us about how experts can assist when there is an issue of parental alienation.
So I think the first thing to think about when you're pondering experts is what kind of experts are there? In the case of alienation, you're already going to have thought about input from CAFCAS and potentially the local authority. Usually there's a Section 7 report, which may be a social worker who's already involved, or from CAFCAS in the usual way. But at the point when you've got findings, the court will really consider those findings just like any other findings of abuse. So when the court has to move on to welfare disposal, what it's interested in is what is the impact on the child, given the findings that I've made. So in the case of alienating behaviours, let's assume the court has made a number of findings that amount to a pattern of behaviour that has alienated the child from the other parent. The court's going to want to know from an expert what will be the emotional, psychological, or otherwise impact on the child from the harm that's been suffered as a result of those alienating behaviours. So really, from RE-C, what we know is there's no change. An expert in relation to parental alienation is treated just like any other expert. So we're looking at Part 25, we're looking at the rules under family procedure rules that govern experts, which is really not particularly prescriptive. And it's for any given court on the facts of a case to decide what type of expert is appropriate. And from the parties who are proposing experts, those parties, it's their responsibility to convince the court that the person proposed has the appropriate expertise. So RE-C in particular dealt with the issue of psychologists, and the primary issue in that case was whether the instant expert, who was an unregulated psychologist, could in any way be an appropriate person to give expert opinion on the issue of alienation. And what the president identified really was it's not for the court to decide whether an expert is or isn't unregulated. And we know that many psychologists are regulated, but not all are. And the court will have to scrutinise whether the person proposed has the right expertise. And I think the emphasis in RE-C is that if a psychologist is appropriately registered, that's a good indicator of someone who has the relevant qualifications. So if I move the slide on, this slide tells us what the two regulatory bodies are in the UK. So the Health and Care Professionals Council, they really focused on clinical psychologists in various specialisms, psychologists who practice and deliver treatment or assessment on a clinical level to whether it's adults or children. And the other body is the British Psychological Society. They offer chartered status, and that's really for academic and postgraduate discipline. So it may be that if you have a psychologist and on their CV they are registered but only under the British Psychological Society, they may not have clinical experience in relation to the practical behaviours that the court has found happened, and won't be in a position to give expert opinion as to the impact of those behaviours, whereas a clinical psychologist is more likely to be the appropriate psychological expert. So Andrew has previously, in earlier slides, referred you to the Family Justice Council, which provided a draft guidance overview of how to approach parental alienation in private family cases following the case of RE-C. And they give some fairly comprehensive summaries as to why you might be interested in having a clinical psychologist over a chartered psychologist, and indeed a registered psychologist over an unregulated psychologist. But of course, it's important to bear in mind that what you're looking for is an overview, a psychological overview of either a parent or a child, that really can help the court understand why the parent is behaving in the way they do, whether they have motivation to change that behaviour, whether they have the capacity to appreciate the impact of their behaviour. And from the child's perspective, it's what is the impact in general on their psychological profile. Might there be any neurodivergent question marks that need answering that might explain their reaction to the behaviours that have been found, or indeed their reaction to the other parent, and a reason why they're finding it difficult perhaps to change their opinion of that parent. So this slide, I think, provides a summary of why you might find an assessment of the child helpful. Again, it's not to ask questions about, is this child alienated, because that really will constrict the ambit of that assessment, and you're more likely to have biased outcomes if you're only asking questions about alienation. So it needs to be a proper assessment of the child's functioning, or of the child's psychological profile, or indeed of the adult. And you might find a case where a family assessment, which is looking at the dynamic of both the adults and the children together, is appropriate, rather than a more specific assessment of the child on their own, or of the adult. And family dynamics are also helpful, where you might have half siblings, because children can have unjustifiable resistance to contact with wider family members. And if that is linked to the behaviour that's found, that's further evidence that alienating behaviours have been happening. So the dynamics between the family might be helpful evidence as to the impact on their welfare, because ultimately the court's looking at the change of circumstances under the welfare checklist, the ability of either parent to meet the needs of the children, and in particular, it's usually the emotional needs. These cases often you find that the practical parenting is okay, but it's the impact of the emotional side of parenting, from the hostility or from the alienation, that is the key question. Ultimately, the court's concerned with whether or not he can change the dynamics of the family to improve the circumstances of the child. And we know from experience that the court can find it very difficult where you have a parent who is very single-minded in their views against the other parent, and you have a child who over time adopts that position. One case I've decided to highlight on this slide, the case of Ree T, a quite recent case. Well, recent in its disposal, but it's actually a case that was going on for over 10 years, on and off in court. And despite findings at various interim points over that 10-year period that one parent was especially hostile in alienating the child against the other, the children effectively reached the point of aging out of proceedings. And this case, obviously highlighting section 9.6, which is about whether you can make a contact order beyond the point of the child being 16, only in exceptional circumstances, really highlighted the difficult position of the court, where even when it's tried all of the options available in terms of therapeutic intervention, local authority support, direct work with the children, you often find that you run out of steam, and the children then get too old before the court has had any success in making a difference. So this highlights the importance of bringing in the right expert following your fact-finding hearing, to understand the impact on the child, and to recommend, importantly, what therapeutic, practical, or other support may benefit in trying to turn the situation around before we get too late in terms of the child's age. Equally, you're likely to have CAFCAS involvement through Rule 16.4. You will want the voice of the child to come through, as Andrew has identified. Evidence of what the child is saying in relation to contact is extremely important in trying to either defend or prosecute an allegation of alienating behaviour. But the voice of the child is also essential in understanding the prospects of changing the child's mind, and the prospects of whether the child will benefit from further intervention. And finally, in terms of experts, you also want them to consider whether removal either straight into the care of the non-resident parent who has against the parent who's been found to alienate the child, or even into a bridging foster care placement, because that might be the only prospect where in a neutral environment you can change the opinion of that child through some further intervention. So bear in mind those outcomes are open to the court. It was previously considered a last resort, but the court's really turned away from that. And what the true focus will be is on a full balance of the welfare analysis, will the short-term harm of the disruption in removing the child from their primary attachment figure be outweighed by the benefit in building up from a neutral place or even into the care of the other parent, attachment with a new primary attachment figure who has a better prospect of promoting both parents' relationships? So, Andrea, I think now we're going to look at some particular examples, and certainly from our experience, how we might unpick all of that in practice.
Yes. So it's important to know at the point where findings of parental alienation are made, what you're actually inviting the court to do after that. So I think the general assumption is that if findings of parental alienation are made, the court will order a transfer of residence to the non-resident parent, and that's just not the case. As James helpfully set out, there are cases where it's unfortunately just too late, because the way that alienation works is that it is a pattern of behaviour over usually quite a long amount of time, where the child has been influenced to the point of no return, which means that actually a transfer of residence is probably the last thing that would help and would probably cause more of a rift with the non-resident parent. And so the case of Re-S is an example of that. And it tells us that just because there is a finding of parental alienation, it does not mean that the court will consider that the court will order a transfer of residence. I'm now going to talk about two cases that I've been in where parental alienation has been an issue. I can see the camera's turned off, but hopefully you can still hear me.
Check with the walls. Yeah.
We can hear you. Okay, great. So where were we? Yes, so two cases that I've been involved with. The first one being a case in which I was acting for the respondent mother. The applicant father raised 18 allegations of parental alienation against her. This was a composite final hearing where the cross allegations were being raised, and then the court was having to make a decision about the children's welfare. What the father was seeking was for a shared care order to be made, and his case was that due to the alienation, he needed to have as much time with the children as the mother to undo the alienating behaviours. The mother, whilst it was found that she did alienate the children from the father, and 17 of the allegations were proved, the court still made a live-with order in her favour. And the reason for that is that they felt that she had shown insight into her actions, she had worked with the professionals, and she was taking active steps to undo the narratives, the negative and harmful narratives that she had previously been sending to the children. So it is possible, even in cases where there are findings of parental alienation, it is possible for the alienating parent or the resident parent to undo that and show the court that they have insight and are moving away from that and can actually promote the contact with the other parent. I had another case, well, it's an ongoing case, in which the applicant father was applying to enforce a final order which allowed him contact with his son. The son is 10 years old, but was refusing to attend contact. He would be kicking and screaming. When he would arrive at the contact centre, contact would break down immediately. He would refuse to enter the contact room. So there were questions raised about why he was reacting like this. And it was clearly disproportionate because he couldn't remember anything that the father had done to him directly. And as a result, the court directed that there should be a Rule 16.4 guardian appointed to reflect that child's views. But the court also ordered for a global psychological assessment of the family. So that's the child, the mother and the father, to try and actually dig deep and see what is going on that deeper level and find out where this is all coming from, which is, I think, what James was touching on with his points on the psychologist and how they can help in identifying the issues. So I hope that helpfully sets out some of what we've talked about in practice. And Zubair is now going to wrap this all up for us and tell us what we're going to do moving forward when parental alienation comes up.
Well, Firstly, just before I do that, I'm just going to add one final point, and that's to what James and Andrea, both of you have said, and that's in respect of wishes and feelings, and also getting experts involved. We referred to the case of Re-S in previous slides, and just to answer a question that I've seen in the chat room, yes, you can have the slides after this session, but the point is that in respect of wishes and feelings, what the High Court said in that case, Re-S, was, this paragraph 63, is that her wishes and feelings are a substantive result of exposure to harmful beliefs and practices which have led to her alienation from the father. So it's not always the case that just because we have wishes and feelings that they are taken at face value. The court's job is to find the ascertainable wishes and feelings, not just the expressed wishes and feelings. And just to wrap this up, is parental alienation a useful concept? I think it definitely is a useful concept. Its case law has shown, recent case law has shown that parental alienation can help us understand why a child is behaving the way they are behaving, why they are opposing contact with the non-resident parent, and it allows us to delve into the issue of alienating behaviors. Is the reason why they are opposing to that contact, is the reason alienating behaviors? And now we have clear guidance from Re-S, which we've referred to again and again, that that's what the focus must be on, alienating behaviors and the impact of them. So that is in essence, to summarize, yes, it is a useful concept, and the ways in which Andrea has summarized how we navigate it through evidence, and how James has explained that how experts can still be useful in parental alienation cases. Those are all the ways in which cases like this should be navigated. We're now just going to open the floor to questions.
Yes, I can see that there's a question in the chat, which I'm going to read out now. It says, if the court does not direct a fact-finding hearing, how can we proceed when the client has made allegations of parental alienation? Experts often don't take instructions in this domain without findings being made first, but the court has not always taken allegations of parental alienation seriously, even when the alienating behaviours are evident. I don't know if James, either of you thoughts on that?
Well, the court has to decide if a fact-finding hearing is necessary, and that's the usual process, regardless of what the type of allegation is made. So at an earlier stage, we need to try and identify parental alienation allegations are being made, and there may be other types of allegations being made, and the court will have to decide in the usual way if a separate fact-finding hearing is proportionate. But even if a fact-finding hearing has been at any point rejected, the court has an ongoing duty at every hearing to review that situation. So if in the question it suggests alienating behaviours are evident, then the person who's worried about that needs to make an application for the court to reconsider its decision on a fact-finding hearing, and set out in that application clearly what the evidence is that gives rise to the contention that alienating behaviours may well be present and of relevance to the welfare disposal. And if you're in difficult, if the court is being difficult about that, then at the welfare stage, you want to start putting questions to CAFCAS or whoever it is that assuming you have a Section 7 report, whoever it is that speaks to that, using the CAFCAS tools that highlights what type of behaviours might constitute alienating behaviours. You want to start raising that these are the types of behaviours that are being seen in the evidence. If that is present, what would be the impact on the child? Or if the child has expressed a hesitance to see their father because of X, Y, Z reason, which is not well supported by the evidence, you might put to that person the weakness of the reasoning behind that might be suggestive of some influence, and question mark, where's that influence come from? If the child is spending the majority of the time with parent X, then the likelihood is the influence has come from parent X in some way. Can you mirror what the child has said with something that parent has previously alleged that the court has not found or to be truthful, or is not corroborated in some substantial way that you can highlight to the court? Or if you're mid-proceedings and the child is, like Andrea explained, unjustifiably resistant to contact, then you might want some kind of psychological assessment. We might want to try and apply for one to try and understand the child's psychological position. And through that, you'll get the voice of the child, the reasoning of the child, and you might identify some particular areas within the psychological dynamic between the child and its parents that could help point towards some therapeutic intervention, which is more of a solution rather than identifying the problem. But if the court is rejecting the evidence that you're presenting about alienating behaviours, then find that it's excluded from the welfare part of the case. So it's something to try and get on top of as soon as you can. But as we know, judges don't always go your way. So you either appeal it or you move on and focus on other areas.
See, I'm not sure I 100% agree with that. I feel like if I had this scenario and the judge refused to direct a separate fact finding, I would probably try and get a direction for it to be considered as part of the wider section 7 and the welfare assessment, in the sense that it might not be a big enough issue that it requires its own separate hearing. And, you know, obviously the court's got the backlog and there's a lack of resources. But I think if you were able to say that it's a serious enough issue that it should be explicitly directed at CAFCAS or the local authority, whoever is doing the Section 7 report should consider it, that might be another way for it to be considered, or at least looked into and put on the table. But I also do think that even if you're not able to get that direction explicitly, the CAFCAS, the client, your client, can raise it to CAFCAS as an issue when they have their interview, and they can talk about their fears and their worries and their concerns, and any information that they sought to rely on in a fact finding, they can refer to that directly to the professionals and see if that can be included as part of the welfare assessment. Because if we're looking at the potential harm of parental alienation, then it is very relevant to Section 7 and to the welfare checklist in general. So I think you can probably get around the fact finding by trying to, I don't know if this is being sneaky, but by trying to get it included as part of the wider welfare assessment, and potentially seeking a composite fact finding, which is what I did in the case in which the findings were made. That was at the final hearing. See if there is a way that you can get a composite final hearing in which the allegations are looked at within the wider context of the welfare decision. So yeah, those are your options. You can appeal and see if that another judge can review as part of that ongoing duty to make their own case management decisions and review all of the information they have in front of them. Or you can kind of just drop the fact finding, the separate fact finding, and see if there's a way that it can be considered as part of the wider welfare assessment or at the final hearing. But I think it's definitely something that I would keep raising in my position statements and keep raising as an issue to the court, because it's important and it does need to be considered. I don't know if you have any thoughts there.
Should we move on to another question?
Yeah, sure.
It's another one about fact-finding hearing.
So is there still a way forward post-fact finding hearing without findings to show alienation is not the issue, the contact reduction? Well, my initial thought is if there are no if they've dealt with the issue of alienating allegations and they don't make findings, then
we go back to what you said. You either appeal it, or that's the basis on which the facts are established. Yeah. That the fact that it's as if the facts established at the fact-finding hearing or determined at the fact-finding hearing, those are the facts that the court will work with at subsequent hearings. So if you think that the outcome of the fact-finding hearing was wrong, then you have to challenge it. And if you don't challenge it, then it will be taken as though you accepted it.
And I do think this is probably where the role of someone like a psychologist might come in handy. If the court is not able to say that there is alienation, but there is still not an explanation for why the child is so reluctant to have that contact, it's one of those instances where you might want to say, we might need a global assessment from a psychologist, we might need them to speak to the child, speak to mum, speak to dad, and find out what's happening, what's at the root of this. So I don't know how helpful that is, but just
one point I'm going to add is that at the final hearing, so that's the welfare stage, one thing the court looks at, one element of the welfare the court looks at, of the welfare checklist the court looks at, is the ability of the parents to meet the needs of the child. And that includes the ability to promote the relationship with the non-resident parent. And that's when alienation can also be brought up. If they are, just because you have not had a fact-finding hearing, it does not mean you can't continue to raise the issue of parental alienation. That goes back to the first question that was asked. Really, don't just think that the issue of parental alienation has been brushed under the carpet because the court hasn't directed a separate fact-finding hearing.
Yeah.
One of the difficulties is you might not realise there's alienating behaviours until later in the case.
That's true.
Because if you're the parent not having contact with the child, you don't necessarily know what the child is saying or what the behaviour is in the home, and you might have suspicion, but it's very hard to evidence it early on. So you might find that it only really comes to light later on, and then you have to kick into gear to try and get on top of that.
Yeah, and I think that's a very good point, especially when we are looking at Section 7 reports. Sometimes it becomes evident when the Kafka officer speaks to the child and tries to get to the bottom of how they're feeling about the other parent. You'll read things like, I spoke about dad, he immediately said, I don't like dad, he hurt my mum, and there's these kind of flags that can go off when you're reading the Section 7 report that go, oh, maybe this should be raised as an issue. And whilst you didn't have enough at the probably the Fahadra early stages point, you might have more evidence now. And because it's a pattern of behaviour, the more time passes and the more of the alienating behaviour you can show, it actually does end up helping your case. So I think, I guess timing is key in that sense. So don't give up just because at the beginning you weren't able to get a separate fact finding. Just keep, I guess, building that case and seeing if there's a way to bring it in at a later point. I don't know if there's any other questions. If you have a pressing question that we haven't answered, feel free to ask it now. If not, we are probably going to end it here. Thank you all so much for coming. It's been a pleasure. We hope that you feel that you've got some answers about parental alienation. I think the conclusion is, unfortunately, it's one of those situations where it's not black and white. It's very much case by case. You'll have to look at the evidence in front of you and see what you can do, whether you are defending the allegations or prosecuting. So we hope this has been helpful, and we hope to see you at our other seminars that our colleagues will be putting on. And we hope to circulate the slides to you after this. So we will make sure we can get those to you.
Just to let everyone know, this will be uploaded. It should be uploaded on YouTube. And what we'll try and do is post the link to the slides underneath the video. Okay. Thank you very much, everyone.
Bye, everyone.